Is our sign language interpreter. The Law Society of Kenya President Faith Odhiambo is facing mounting criticism after accepting to serve as vice chairperson on the newly sworn-in panel tasked with developing a framework to compensate victims of protests and police brutality. It is a move that has sparked mixed reactions within legal and civil society circles. Chebet Birer tells us more.
I, Faith Odhiambo Moni.
And even before she settles down on her new responsibilities, many critics, including her colleagues at the Law Society, are not happy with her decision. Levi Munyeri, an advocate of the High Court of Kenya, has already threatened to initiate her removal from office if she does not resign from the panel. In a letter dated 4th September 2025 and delivered to LSK offices, Munyeri says, and I quote, "The panel has duplicated the function of a constitutional creation, the Kenya National Commission on Human Rights, KNCHR, whose functions are outlined in Article 59 of the Constitution to include to receive and investigate complaints about alleged abuses of human rights and take steps to secure appropriate redress where human rights have been violated." Patently, the president of LSK has taken an oath to serve in a panel of experts that is anchored on unconstitutionality. More critics argue that the constitutional framework further allocates these responsibilities to the Office of the Director of Public Prosecutions, ODPP, the Independent Policing Oversight Authority, IPOA, and the Victims Protection Agency, VPA. The President's unilateral creation of this panel therefore duplicates and undermines these constitutional organs, breaching Articles 1(1), 2(2), 10(2), and 129(1), which establish the supremacy of the Constitution, the rule of law, and good governance as national values.
There is a step that is being skipped. We have not seen any of those perpetrators, those who came in Subarus. None of them has been brought to book. None of them has been, arrested.
Munyeri argues that Odhiambo's involvement compromises the independence of the Law Society of Kenya, an institution expected to remain neutral and hold the state accountable. Other critics argue that joining a presidential task force blurs the line between justice advocacy and political endorsement. But Odhiambo has defended her decision, stating that her involvement ensures transparency and legal accountability, and that the victims' voices will be safeguarded through legal representation within the process.
In this exercise, my service will be solely to the people of Kenya. There is no Kenya that belongs exclusively to politicians or their children. Neither does it belong to broad-based government, nor a country of cousins.
Another letter dated 5th September and written to the CEO of the Law Society of Kenya by Advocate Paul Kiragu Wadhuta argues that while the imperative of delivering justice and reparations to victims of police brutality and public protests is commendable, it is essential to interrogate the constitutional propriety of the panel's establishment. Kiragu goes ahead to quote Article 132(4) of the Constitution of Kenya, which clearly circumscribes the powers of the President to those expressly conferred by the Constitution or by an Act of Parliament. The panel, however, was constituted by presidential proclamation and gazetted without any enabling legislative framework or recommendation by the Public Service Commission.
Should my efforts be frustrated or cannot be or undermined in any manner whatsoever, I am prepared to do the honorable thing in fidelity with the rule of law and the Constitution of Kenya.
Faith Odhiambo is now caught up in a clash between personal conviction and professional expectations. Whether her choice was based on moral duty, legal insight, or public service, it is now subject to institutional accountability. In yet another letter dated 5th September 2025, Advocate of the High Court Francis Wanjiku has written to the LSK CEO requesting for a general special meeting to discuss Faith Odhiambo's service to the society, and I quote, In light of these concerns, I respectfully request that the Council, pursuant to Section 16 of the Law Society of Kenya Act 2014, convene an extraordinary general meeting of the LSK membership to deliberate and decide with finality whether the current president should continue to serve in that capacity. The letter continues to state that this matter is of such gravity that it warrants the democratic input of the society's membership to ensure that the LSK's leadership reflects its core values of independence, integrity, and public trust.
This is selective justice, and I don't like it. It is selective justice. And we don't... Money, by the way, you can't solve problems by throwing money at it.
Meanwhile, all eyes will remain on the panel's ability or inability to deliver real justice and on how LSK's involvement shapes both the perception and outcome of the process. Chebet Birir, KTN, Nairobi.